Good afternoon. Thank you for taking the time to attend this is our third webinar this year on employment handbooks. The man behind the voice you're hearing today is attorney Carl Habekost, and we have Elizabeth Bolduc, who's an attorney in our labor and employment section. Together today, we hope to present a very informational and entertaining webinar on employment handbooks. Elizabeth, do you want to take off here?
Sure. This is, as Carl said, multiple series, so we've done a few, but it's always great to kind of refresh where we last left off, and we are talking about employee handbooks and, what should be in an employee handbook and kind of some tips and tricks. As you'll remember, we talked about an employee handbook really is a communication tool. It's a communication tool of telling your employees what you expect out of them and what they should expect from you. It also provides really good information. And today, especially, we're talking about time away from work. And to most employees, that's very important. What kind of things can they be excused for? What are their expectations with showing up to work, at what times, things like that. And then also it provides legal protection. So, of course, that's our aspect on it. There's a lot of times we will look at, attendance policies or FMLA policies, and we see errors are in it and things that would have helped to provide the employer with a little bit of protection if they had certain language. So it's a good thing you all are tuning in so that you will be ahead of the curve and know what things attorneys look for and to help protect your company. All right, so just to kind of recap what we've talked about, what does a typical handbook look like? Of course, you're going to have your introduction with welcoming statements, disclaimers that it's at will, and then, the right to change your policies when you need to, and then kind of like the day-to-day work rules, so code of conduct, things like that. Benefits, do you provide medical benefits, vision, dental, 401k? Today we're talking about, of course, leaves of absence, the time away from work. And then you have kind of the end of the handbook of end of employment, and then, of course, a receipt and acknowledgement. All right, and then today we're going to go over, what do holidays policies look like, vacation policies, personal days, 6 days, attendance, what kind of disability leaves should you offer, what about the FMLA, pregnancy, maternity, paternity, what about military, and then just other various leaves. So this just kind of gives us a game plan of what we're going to be discussing, and hopefully these are all things you'll take away with you.
We can even call our webinar today absence management.
Yeah.
It's becoming a very time-consuming and a legal minefield for employers. Holidays. Well, this slide really spells out the basic issues for holidays. If you are going to provide a holiday from work for your employees, you need to state it. You're not required, isn't that right, Elizabeth? They're not required to provide a holiday, but if you're going to have a holiday, let's just say Christmas or New Year's, for example, indicate in there whether it's a paid or unpaid holiday leave. I'm going to throw it in there even though it's not on the slide. If somebody is paid for a holiday and it's in the middle of the week and the employee worked 32 hours that week, but they were paid 8 hours for a holiday, and then they happen to work 4 hours additional on a Saturday, and your work week runs from Sunday through Saturday. Does that mean that the 4 hours are overtime, qualify for overtime under the Wage and Hour Act, Elizabeth?
So under the overtime laws, you only have to be paid for actual time worked. And so holidays or PTO time or anything like that, that's not actual worked hours, does not trigger overtime laws.
So even though they're paid for 44 hours of time that week, they actually only worked 36 hours and therefore would not be overtime. That's just a little point I thought we'd bring up.
Yeah.
So here are some best practices, tips for holidays. And that's the important part of having a handbook. You're communicating to your employees issues that are important in the workplace, and that includes time away from work. Identify the holiday schedule. As we indicated, communicate whether that is a paid or unpaid holiday, whether the offices or the plant is open or closed. Is there anything else you think is important, Elizabeth, on this slide?
Yeah, so you're going to first want to identify your holiday schedule. So considerations would be, are you going to kind of run with the state's holiday schedule, maybe the federal holiday schedule? You know, what makes sense to you? And so culture comes in a big thing here. And if you have a very diverse culture within your organization, you're going to want your holiday schedule to be diverse. And so maybe not, you know, the traditional federal holidays. So things companies are doing nowadays is to leave a lot of room for flexibility to accommodate people who have diverse backgrounds. So a lot of companies are now rolling out just 2 open holidays, flexible, floater, you can call it really whatever you want, but you know, you have these 2 holidays that you give employees to use whenever they think is important. Of course, they're going to have to provide, you know, what kind of notice that you need, but you know, whether it's their birthday or whether it is the Chinese New Year, whatever holiday that they think is important and worth taking a vacation or a holiday day. So that is a way to kind of get away from maybe a religious discrimination claim or something like that, that you're failing to accommodate those with a religious need to take off a holiday, is that you can build your policy in to kind of protect you and isolate you from those, you know, considerations. And I think a lot of things here is just communication. So it gets confusing sometimes when you require employees to show up to work, but other employees not. So sometimes office employees do not have to come to work on a certain holiday, but the line level factory workers do, because you have production needs. And so if that's the case, maybe you just pay the production individuals a premium, you know, time and a half or whatever the case. But this is really a chance for you to lay out what makes sense for your organization and how you want to do it.
So just touch base real quick. You said accommodation for a religious holiday. So different religions have different holidays. So for example, Christians celebrate Christmas. If you have an employee who is not a Christian, but perhaps they're a Muslim and they have a different holiday, religious holiday, is that what you're referring to in this slide?
Yes, so that's kind of some ways companies are addressing it now. It's just to have flex holidays that they can take whatever day they want off because they have those floater holidays, and that way you're not discriminating against someone or treating one religion more favorable than another.
We have a question, and they just wanted to know, premium pay is employer discretion?
That is right. So the nice thing about holidays is everything is the employer's discretion. So I actually get a lot of people who say, wow, we didn't realize that. We just figured that you always had to pay employees for time off work for holidays because, you know, the federal government has come out with a list and say these are the recognized holidays. But that is always an option that the employer has, whether or not to pay someone to work those days and that is same with premium pay.
Okay.
All right.
Paid time off. So we just talked about, I believe, maybe we didn't, because I'm aging, maybe I forgot. But I think we did mention something like around vacations. The new trend for employers, as this slide suggests, is to go away from labeling time off for vacation, sick time, personal time, and just call it PTO. That stands for paid time off. What is the advantage to that for employers? Do you have any thoughts?
There's a lot of less tracking for HR, so I'm sure most of you who are listening right now are in the realm of HR. And as you know, when you give employees these types of benefits, it creates a lot of paperwork for you because you have to track all of the vacation time. And so if you have 3 different methods that an employee can take time off, it gets really complicated really fast to say, oh, this is your sick time, this is your personal time, this is your vacation time. And so it's kind of just an ease to say, you know what, we're giving you 3 weeks or whatever the case may be, 2 weeks, 9 days, however your company feels is best, and say you use them however you want. This is your paid time off. You want to go on a vacation, go for it. If you don't feel good that day, you want to take a self-care day, which is the new trending thing, do it. Paid time off really should be time away from work so your employees can relax and rest and come back to work fresh. And so on the employee front, statistics have come out to say that employees do feel way more refreshed in this type of system because they're not lying like they used to back in the day when they used all their vacation time and they only had 6 days left. But of course they're not sick, but they wanted to go to their child's gymnastics meet. And so they felt pressure to lie and say, I'm sick this day. And so now that kind of eliminates that, and employees can just take the time off as they see fit.
Okay. Does that avoid also any potential problem that we have seen in our cases where the handbook may say you're entitled to 10 days of vacation time rather than the magic language we use to avoid when somebody just up and quits and then they claim vacation time. If you have paid time off, can that avoid some problems down the road when employees separate?
Yeah, I mean, I think what you are talking about is like a accrual system. Mm-hmm. And so there's some older cases that said, when you earn something, you're entitled to be paid out. Courts have kind of moved away with that. We're actually going to get to it. So, Carrie, if you want to transition.
Sorry about that.
No, that's good. No, that's good timing. Yeah. So, some things to consider in the PTO policy, which is kind of what Carl was getting at, is you're going to want to identify whether the policy is based on accrual system or seniority system. And so, for a long time, there was this theory, and I think it still is a theory that people use, is not to use the word accrual because courts would interpret that to mean that you are owed something. So granted is the more favorable, or entitled, or something around that fact. Now companies tend to put disclaimers in it, which we'll get to, which have seemed to work. So whether, based on how many hours they work, they get this many vacation days or PTO days. And then, or is it because they've been there from 0 to 2 years that they get 2 weeks, and then 3 to 5 years they get 3 weeks, and so on and so forth. And then so you'll just want to kind of identify at first how are you coming up with this system? What is the system? Maybe it's the same for everyone. On the first day of hire to your 30th year here, you get 3 weeks, and you can use it however you want, when you want. It really has to come down to a business decision of what makes sense to your organization and what you can accommodate. you're going to want to talk about whether there's a cap. So if you are in fact accruing or there's a seniority system, at what point is there no more? So saying the maximum amount that you can ever get is 4 weeks or whatever the case may be. And in addition to that, you're going to want to address whether employees who don't use it can carry it over. So say I only took 2 weeks in 2019, but I have 1 week left. Can that carry over to 2020? Or maybe it can't, and we have a use it or lose it date of December 12th. Courts have found when employers put the specific language in a handbook, you are protected. It's when you don't have these language in your handbook that you start to lose your privileges, I guess, or your protections. So that's why it's really important to make sure that all of these considerations are addressed in whatever way that makes sense to your organization. And so, the next two are probably the most significant. You're going to want to say whether or not, upon separation of employment, you pay out this time. And so a lot of companies are moving into the direction where pay time off really is to be used during that calendar year so your employees do not get burned out. And there's a lot of companies that are moving to the direction of not paying that time out because it does incentivize employees not to take their vacation time and just work and, leave the company with more money. So you'll want to address that. There's not a right or wrong way to do it. There's certainly a trend of what companies are doing nowadays, but you will want to address it in your handbook. And then also you can say, well, we might pay PTO out, but an employee becomes disqualified from that benefit if they don't provide us 2 weeks notice or 3 weeks notice or whatever you require. Maybe returning your keys or however you want it. But if you put all these disclaimers and cover all these things, you're going to have a pretty solid policy.
Okay. Thanks.
All right. So attendance tends to be one of the top calls that Carl and I get. So we're having a problem with this person coming in, or this person came into work for 3 days, can we do? And the first thing Carl and I say is, can we see your handbook? Let's see what it says so that we know how to enforce it and, how to apply whatever you have agreed to. And so, I'm in the track that attendance policies should not be very long. The more clear and concise the policy that you can have, the easier it is for employees to understand what is expected of them and the consequences if they violate the policy. And so when you're drafting attendance policy, you're going to really want to talk about your culture. So sometimes companies take a very strict approach and there's 0 tolerance, meaning that if an employee is late 5 minutes, that there's going to be consequences. Well, there's other companies that it doesn't really matter as long as employees are getting their work done. So the traditional 8 to 5 or 9 to 5 is kind of out of the window, and there's flex time in the sense that as long as you get your 9 hours or 8 hours in, we don't really care what time you get here, what time you don't. And so you can lay that out, whatever makes sense to your organization. And then we're going to get into this a little bit more later in the presentation, but I wanted to put a disclaimer here so that we don't forget. In all of your attendance policies, you should have a kind of a disclaimer that these leave things in this policy, has a carve out for any ADA or FMLA issues going on. So if someone has a disability or has maybe intermittent leave, that this attendance policy might not apply to them in a certain way.
A question that came in from the last slide.
Oh, sure.
Can an employer disqualify the payment of PTO accrual for involuntary termination, such as layoff or firing?
Yep, absolutely. So a lot of times employers will say, we only pay it out if, it's a voluntary quit. And so when someone is terminated, they will disclaim it right away. And courts have agreed with that language and have pretty much interpreted it as written. So that's why anything that you want, you should make sure is in your policy.
So as long as you put it in your policy and you let your employees know, the court says you're okay.
Yeah, so courts really consider the notice provision here that you're putting on your employees on notice of the benefit to them and how it applies to them.
Okay. Well, this slide looks like it's a fairly important slide because what we run into, I think, Elizabeth, on a regular basis is a failure to define the terms. What do you mean by tardiness? Somebody can be 10 minutes late. Does that count as a tardy? Does it count as a tardy if they're 10 minutes late, but they notified the employer, look, I got caught in a traffic jam. I was beyond my control. I'm going to be right there. Does that count as a tardiness? Do your employees have to call in, say 60 minutes before the beginning of their work time to give notice that they're going to be absent for the day? What if they're only absent for part of the day and then they come in and work the remainder of the day? You talk about that in your attendance policy. You have to distinguish between what would be approved absences and unexcused absences. And are approved absences subject to discipline or not? Almost always unexcused absences are subject to discipline. We see in almost every policy, no call, no show for 2 days is considered to be a voluntary quit or a voluntary abandonment of employment. Employers want to make sure that they identify when disciplinary action is going to be taken. So, for example, after 2 unexcused absences or 1 unexcused absence, or do you have a no-fault system?
Yeah, so it really just depends on your organization. Some employers are going with the no-fault system, which we're going to get into after we talk about the ADA and the FMLA and how courts and the EEOC has kind of put their distaste for those policies. And there's other ways to do it, though. You can have a point system. You could have just a regular disciplinary policy where it doesn't matter if someone was late to work or they got in a fight at work, but it's a written warning. It's a verbal, it's a written, and then it progresses. You really have to make sure it makes sense to your organization. There's multiple ways to do it, so that's why we didn't get into the specifics of, there's this system or this system, because there's a lot out there. Mm-hmm. And every organization is going to vary based on the size, what they can accommodate. So sometimes, this isn't a huge deal to a lot of people because they can work from home whenever and they can come in as they please. So culture, I know I say that a lot, but really matters when it comes to these policies. And so when you are revising an attendance policy or maybe starting one from brand new, you're going to really want to consider what makes sense to our organization. How do our employees ready act? Is there a behavior we're trying to correct here, or things like that?
Well, let me ask you a question. Let's say that a company has 15 people working in the office, and several of the office employees have the ability to work remotely due to the computer technology, and they have 50 people working in the plant, and that's a production facility. They cannot work remotely when they're doing production. They have to be there, have to be at the machine, or they have to be at their job rotation. Can a company have 2 separate attendance policies?
Yeah, I mean, you can have, it gets very confusing to do so, and it can become complex, but as long as you do it by department and you have a business justification for doing so, so it's not treating 2 secretaries completely different, saying, I'm going to use Carrie because she's in our office. She's with us right now. Carrie, you have to be here at 8 o'clock, but telling another office worker that they have to be here whenever they please or come and go. So you're not treating similar employees differently.
Got it.
You're treating departments differently based on a business need, and that's okay.
Okay. Good, thanks.
All right, so now we're going to get into kind of the more leave side of it. We're going to talk a little bit, not too much about workers' compensation leave, but I did want to bring your attention to it. But we are going to spend some time talking about the ADA and FMLA because that seems to be a huge issue for employers in the sense of having employees on an ADA leave or an FMLA leave, and it gets confusing because there's time for all three of these things can overlap.
Right. Well, we run into this a lot because we have a significant workers' comp practice that blends right with our employment practice. So when somebody gets hurt at work, that's a major life impairment, so they're off of work under the workers' comp claim. But then that also takes into play the Family Medical Leave Act leave, which I know you're going to talk about. But I wasn't supposed to be here today. I was supposed to be out of town at a hearing, so I have the opportunity to talk, so I'm going to talk.
There you go.
And then the ADA can come into play when somebody is released to come back to work, but they have permanent restrictions. So we're going to cover all that now, right?
That's right.
Great.
All right, so just kind of, I'm sure everyone knows what the ADA is, but for anyone who doesn't, the ADA is also known as the Americans with Disability Act. It is a federal civil rights law that prohibits employers, among other people, to discriminate against individuals with disabilities. And so a disability is a physical or mental impairment that substantially limits a major life activity. You can also have a record of having an impairment or be regarded as having an impairment. So even though you maybe don't have an impairment, if someone perceives you as having one, that's what triggers the ADA. And so, we're going to talk about, this isn't an ADA training, so for anyone cringing right now, we're not going to be training on the ADA, but we're going to just talk about, how does your policy look and what are the kind of leaves that are associated with ADA. And so companies should have a policy stating that they will accommodate an employee with a disability, so that they can perform the essential functions of the job, unless doing so would either cause a direct threat to either themselves or someone else in the workplace, or it creates an undue hardship on the company. All right, so a reasonable accommodation is pretty broad. It's any modification or adjustment to a job, maybe a practice, even a policy, which would allow an employee or an individual with a disability to be able to perform the essential functions of the position, meaning that they can do the majority of their work, the really important stuff of their job. And so some common examples are, modifying a work schedule, allowing someone to work from home, getting new equipment, taking time off from work to go to doctor's appointments, maybe to get chemotherapy, maybe to go take injections, things like that. I think that's commuting already, so working in a remote area, and then, leave from work as well.
Well, what is this? I want to work in a quieter space. Is that a reasonable accommodation?
Yeah, it can be. I mean, of course, you have to have all the things that trigger the ADA, so someone has to have a disability under the definition I just gave. I won't bore anyone again. But, so say they have ADHD, which substantially limits a major life activity, and they get distracted by really loud coworkers, and it's not a good environment for them because they can't focus. They could say, I have ADHD, it's recognized, and I need this reasonable accommodation of maybe moving to a different office or working in a more remote location. And so that is definitely a reasonable accommodation.
All right, we have another question. In the handbook, would you recommend adding examples of accommodation?
You can. It's up to you. I don't think there's a right or wrong way. I always am a fan of giving examples because it puts employees on notice of things that they're entitled to or ways that they might want an accommodation. So if an employee has a disability, they might not even know what is a reasonable accommodation. But if you say, here are the type of things we're willing to do, it might give them an idea of what would work for them, and then they can come to you and say, hey, I think this is a good idea, and you could agree with them. So it could take a lot of work out if you just give them some examples.
As long as you put a disclaimer in there, these are just examples and not limited to these.
Yeah, of course. You're not going to want to say these are exactly what we'll do in our situation, but some common examples are these. Yeah.
Okay. Oh, well, when is a reasonable accommodation an undue hardship? There are several factors, and frankly, this is a pretty tough element for the employer to prove based on what I've seen in the court cases. Would you agree?
Yeah, so the reason I think you say that is because it's such a case-by-case analysis, meaning that there's a lot of factors, and so there's not a cookie-cutter answer.
Right.
And so that's what we mean by it's a little bit harder for employers because it really depends, the lawyer's favorite word.
Sure. So, for example, a small company with 10 employees, that may not be the right number, let's say 25 employees, may not have the financial resources of Apple or General Motors. So for them to spend, or a small company to spend $50,000 to redo a workstation to accommodate somebody with some extensive disabilities might be a financial hardship that would prevent a reasonable accommodation in that instance, where for General Motors it wouldn't be, more than likely. But there are also a lot of grants out there that employers aren't quite aware of, so the government provides a lot of grant money to help individuals with disabilities so that you can provide a reasonable accommodation. Geographic separateness. What do those words mean to you in the type of operation for the employer, including the structure and functions of the workforce, the geographic separateness and the administrative or physical relationship of the facility in making the accommodation?
Yeah, so it's just going back to, what does your company look like? Do you have multiple organizations within a few miles of each other where you can swap out employees? Do you have a huge workforce? What are you a single business located in rural Ohio? What does it look like? What are the finances going on? Can you afford this accommodation? Maybe it's not even financial, but it involves, removing someone from a position or something like that. Can you accommodate it?
Maybe the employee pool isn't as large in a rural area as it is in a metropolitan area. But the key point of this is the very last sentence or the bottom of the slide. It's an individualized analysis, and the process needs to be documented. Mm-hmm. So all of the conversation with the employee and the considerations that the employer made in trying to accommodate the employee's restrictions need to be documented. Now, you may have this, or we may have this in the slide coming up, but just so the employers know that they do not actually have to create a new job for an individual to comply with the Americans with Disabilities Act. Is that correct?
Yep.
Okay.
All right. So we're talking about, I promised you that we were going to do a full training on the ADA, but we're going to just talk about how the ADA relates to leave, since we are talking about time away from work. There was a really common idea that the ADA does not provide for leave for a long time. And the courts have kind of changed their mind. So, you know, the ADA does require employers to provide employees with a reasonable accommodation. It does not specifically address whether or not leave is to be provided to someone who has a disability, just simply that it must be a reasonable accommodation. Courts have started to think and started to come out saying that a leave from work is a reasonable accommodation under the ADA. And the EEOC, which is the one of the agencies that enforces employment regulations, has a very, very strong view on this, and they view leave to be a reasonable accommodation, especially when it enables an employee to return to work following a period of leave. So a lot of times this comes up when someone is on an FMLA leave, maybe a workers' compensation leave, or whatever the case may be, and they just need a little bit more time.
So like 2 months or 3 months?
So, you know, courts, this is kind of the gray area where courts are at. You know, courts are all over the place in what they think is reasonable, and I think that's because it's a case-by-case approach. You know, again, what does it look like for your organization, and is it actually reasonable for your organization to accommodate that? So courts have, in our circuit, and our courts that we follow here, have kind of given us guidance. Of course, this isn't, you know, a hard and fast rule, but around 6 months typically tends to be reasonable. Anything more than 6 months gets to the realm of being unreasonable. And of course, a request for forever leave or leave that is, you know, unknown, a period that is unknown, is not reasonable.
Okay. Our favorite Family Medical Leave Act. I've known people to break out in hives when we get to Family Medical Leave Act.
That's why we're doing a webinar, so we can't see anyone breaking out in hives.
This is actually sort of a nice slide with the roadmap there. Identifies some of the issues that employers and employees can run into on family medical leave. Family Medical Leave Act entitles, and it's eligible employees of covered employers to take unpaid job protected leave. And because we're always limited on time, we're not going to get in totally into the weeds, but we will identify what we mean by those terms: covered, eligible employees and covered employees, covered employers. But it is a 12 weeks of leave for a 52-week period that the employer can identify.
Yep, so I think you were just getting at this. And I don't think we said it for the ADA, but of course there needs to be 15 or more employees for the ADA to apply. But the FMLA does have a higher threshold, which requires 50 employees within a 75-mile radius. So if you have, you know, less than 50 employees here in Ohio, and then say, you know, in Alabama you have more employees, together that doesn't reach the 50 threshold. It does have to be within a radius of each other. And so to be eligible, for an employee to be eligible, they do have to work 1,250 hours in the last 12 months, over those 12 months. So there are certain reasons why an employee or how an employee can take FMLA. And a lot of times the policy will lay those out. All right, so, you know, kind of what is the overview of what an FMLA policy really looks like? Well, what Carl and I just discussed, your first one I want to start with, what is FMLA? Well, it's a federal law that allows employees to take 12 weeks unpaid leave for certain reasons. And then you'll want to say who is eligible, and then, you know, when is there a qualifying event. And so sometimes employers will choose, even if they don't have 50 employees, choose to follow the FMLA and provide this type of leave. So if you're in that camp, you just want to specify that the FMLA does not apply, but you're willing to provide 12 weeks unpaid leave, similar to the FMLA regulations, or, you know, something to that extent. And for many of you who deal with FMLA, you know that it requires you to provide your employees with general notice that they have a right to take this type of leave. And so that's what handbook provisions are particularly good for. It kind of checks that box, and you can provide all of your employees with this notice when you give them the handbook during orientation and have them sign off on it. Then you've kind of done your due diligence of giving them notice that the FMLA applies to them and how they can request it and all of those nuances.
Now, in our jurisdiction, under federal law, employers can designate leave as FMLA. The employee doesn't necessarily have the control or the authority to say, I will take this as FMLA or I won't. The employer can identify leave as FMLA, correct?
Yeah, so when there is there's a qualifying event that covers
like a workers'
FMLA.
comp injury or something.
Yeah, so as long as it triggers the FMLA, an employer can say that you're taking FMLA. In fact, there was an opinion letter that just came out from the Department of Labor who said, you know, you can't substitute leave for FMLA.
Okay. Just so the employers understand they have that authority.
Yep. And so you're going to want to describe the procedure for requesting leave. So this is really where the meat of the policy should come in. And, you know, we don't have any samples here because it looks so different for every organization. Maybe it's requesting it from this person at this time, or getting these paperwork, or maybe you have a third-party agency or administrator who does it for you. You know, but typical things that go in it is that when you have foreseeable FMLA leave, maybe like a surgery or a pregnancy, your due date, you can ask in 30 days in advance, but sometimes it's unforeseeable. So if someone were to get in a car accident and was in the hospital, of course, that would put them on FMLA leave, but obviously they could not ask for that leave. And then this is the one that I think is the most significant that we see in our office or we have problems with, is people not calling into the right procedure. So maybe if someone is taking intermittent leave for FMLA, they still have to follow the call-in procedure. So whether it's calling their supervisor within 5 hours, the night before, whatever you want it to say, and you can enforce that. So although you can't discipline an employee for taking FMLA, you can discipline an employee who does not adhere to the policy and the call-in procedure. You also want to address benefits. So companies do it multiple ways. While you are on an FMLA leave, the employers are required to continue your benefits. And so there's certain things that employers will want to say about how they're going to collect the premium from the employee. Sometimes they'll just pay it and then expect the employee to reimburse them. Sometimes they want the employee to keep making those payments, but of course they're not working, so you can't take it out of their pay. So you'll want to address those issues there. And that way, if, for instance, an employee just doesn't come back from FMLA leave, you know, how do you handle that and recouping those costs? And, you know, whether they're getting paid during this leave, of course, the FMLA provides for unpaid leave. Some companies do pay, and so you'll just want to make sure that you address those types of things. The one nice thing that the FMLA regulations does is it gives employers the ability to tell employees how they're identifying the 12-month period to calculate the FMLA. And so this is one thing that is a must in an FMLA policy, is describing how you do this. So is it a rolling back? Is it a calendar year? There's a few ways you can do it. You have to figure out what is easiest for you to track or what makes sense for your organization. For intermittent leave, you have to allow an employee to take leave in increments that can be taken for other leave. So if someone can take a half day for PTO or 30 minutes, you have to do the same for intermittent leave. So you'll want to address that in your policy. You also want to say whether sometimes you have to use some of your PTO time, for 20% or whatever the case may be, whether that runs at the same time with FMLA, and then what happens if they just don't show back up, or don't return from work, or they don't give their paperwork that they can return to work. So those are all things we're going to want to address in this policy. And of course, anything else that makes sense to your organization.
I think our audience would be stunned at how often we have cases where the employee simply just doesn't return the paperwork or doesn't come back to work, and then they don't know what to do with them. And it should be addressed in your attendance policy.
Yeah.
Okay.
I do have another question here. If we have several companies under family companies where all but one of less than 50 employees, are we required to offer FMLA to the others of less than 50, so we could be considered a common employer?
So if you're a common employer under the actual regulations, then yes. Like if you're considered one employer, if you are opened in a way that you all are sub-companies, that you aren't tied to one another, no, it gets very complicated. So without knowing more facts, it's hard to give an answer. But if you want to email Carl or I after this, and we can get more specific.
Yeah, it gets complex. Like you have common ownership, you have a certain percentage, it would be different ownership. You have common HR department operating all of the companies together. Just, it's about as exciting as watching paint dry, I think. Overlap between FMLA, ADA, and workers' comp happens quite a bit. Under all of these laws, somebody has a disability and they're taking time away from work, and this is where the term absence management is very applicable. The amazing thing is how often all three of these laws intersect and how often they come into play involving the same employees. Here's an example. A workers' comp injury requires hospitalization or it incapacitates an employee for more than 3 days and requires continuing treatment by a healthcare provider, generally qualifies as a serious health condition under the FMLA. If the injury causes a permanent mental or physical impairment that substantially limits a major life activity, that same employee could be entitled to additional leave as a reasonable accommodation under the ADA. So if somebody is injured at work, maybe they get cracked in the head and they're off of work for an extensive period of time, but they end up with post-traumatic stress disorder and they need more time off of work. So they've exhausted the FMLA because the company ran workers' comp and FMLA together concurrently, but they have a permanent issue that needs reasonable accommodation. Let's say they need another 3 months off of work because they're going through some kind of PTSD treatment, post-traumatic stress disorder treatment. That's an example of a reasonable accommodation under the ADA. Does that make sense?
Yeah.
Yeah. You could say no.
All right. So I promised you that we would get into these NoFault or inflexible leave policies. So now that we've talked about the ADA, the FMLA, and attendance policy, let's spend a few minutes to talk about this. So NoFault attendance policies or leave policies started to become pretty popular in saying, we don't really care the reason that you're not coming to work, but you get this many points for not coming. And so government agencies have come out and say, well, we don't really like these type of policies because for employees who have an FMLA or who have a disability, it can violate these laws, so the ADA and FMLA. And so that's something to be cautious of, and that's why all leave policies should have a carve-out for anyone who needs additional leave under the ADA or FMLA. Another thing is to watch for is just automatically terminating an employee after being gone for 6 months or whatever the case may be. I worked in-house prior to coming here, where we would send out letters to employees, whether they were contingent employees, temporary employees, or full-time employees who were on leave, who didn't work a certain amount of time, and just said you're automatically terminated because you didn't come to work for this many days pursuant to our policy. And that's kind of gotten employers in a lot of trouble because it doesn't allow for extra leave. And so if you are doing those things, there's ways to put disclaimers in it that you do not violate the law. And so you can put just a simple paragraph saying, if you need additional leave pursuant to these things, like I said, the ADA, FMLA, please contact us and we will work with you. It's when you have no flexibility at all that you really get in trouble. But when you make it clear that you are willing to work with someone who needs a little bit extra help, that you have some saving grace. And just to show you how significant the government has been, there has been, I mean, these are just starting examples, but there are ongoing examples where the EEOC has brought suits against employers for having these really rigid and unflexible no fault or automatic termination policies. So it's just something to be cautious of. And as long as you put in there those disclaimers that we've talked about, it will show your willingness to accommodate those employees who need it.
Okie dokie.
All right. So, we kind of touched about pregnancy leave, some maternity leave. Sometimes employees can take it for FMLA. A lot of times people will wait until they actually have the baby to take the FMLA leave, but sometimes employees will want to take it before, a couple weeks before. Sometimes it can actually be a reasonable accommodation when someone has a disability associated with being pregnant. And so sometimes that kind of leave is required under the ADA. But just keep in mind the Pregnancy Discrimination Act, which is the PDA, is also at play here. So if you allow other employees to take a certain type of leave or leave without pay, you must also do the same for someone who is pregnant. So those are just kind of a quick reminder.
And just a real quick question. Does it matter whether you call it in your handbook pregnancy leave or maternity leave?
No, names don't.
Names don't matter on that?
Yeah.
Okay.
And so when we're getting into maternity and paternity leave, which is kind of more traditional sense of it, I use pregnancy leave really to mean someone who is pregnant and wants leave while they're pregnant, where paternal and maternal leave is once, typically once the baby has been born. Of course, we're talking about the FMLA might apply, but sometimes the FMLA doesn't apply because you don't have 50 employees, and then you're left with, well, what do we do? And so we operate in Ohio, and in Ohio, there is no state law requiring employers who have less than 50 employees to provide these type of leave. However, other states like California, New York, New Jersey, Massachusetts, Rhode Island, there are various provisions of family leave. So I think this is going to be more common, but for now, Ohio is not one of those states. Michigan is not those states. So you have some discretion of what makes sense to your organization.
Right. And somebody brought up a question, isn't it a sense of discrimination that you grant, 6 to 8 weeks for a pregnancy leave or maternity leave, and you don't give any leave to the dad, or you only give a couple of weeks? And somebody said it's because the actual leave for the woman who had the baby is recuperation period for her body after having the baby. It's not necessarily a baby bonding period.
Yeah, so the FMLA does account for baby bonding. That's kind of one of the purposes where both mother and father can take leave. But yeah, a lot of times there is maternal leave because the woman is recovering from giving birth. But, you know, again, that's a business decision, not a legal decision.
Right.
As long as you have a business reason of, you know, how you're coming through your
legitimate
policy.
business reason.
Okay, so we're getting more into the miscellaneous types of leaves and just quickly going through a few of these. Military leave, you know, of course there's FMLA here that might account for leave, but the USERA is another provision that applies to any employer, no matter how many size, and it just provides a right for individuals who are in the armed forces to go on leave and come back into the same position they would have been in if they would have not left, with the same type of benefits accruing if they would have stayed. And so that's just something to be cautious. I don't think this is a huge thing that you have to put in your handbook. You don't need I've seen handbooks with these USERA's policy.
Quoting the entire act.
And I don't think that's necessary, but it's just great to be aware of these things so you can address it when it comes up, or maybe just a quick paragraph. Sometimes I see miscellaneous leave. I think that's okay, saying military leave, jury leave, bereavement, whatever, just a small paragraph on all of these things, because it is going to depend. Maybe you are in a location where there's a lot of people who are enrolled in the armed forces, in, you know, kind of the reserves, and then maybe you're in a really big city where you don't have very many. So whatever makes sense to your organization. Jury duty, we get this question a lot. I don't know why we do, but we do. In Ohio, there is a state law that prohibits employers from terminating or taking adverse employment action because someone missed work for going to jury duty. This isn't going to court because they violated the law, but this is because they are doing their civic duty and serving on a jury. And you can't discipline someone for it, but you don't have to pay someone. You can, so if you want to pay them, you would just like lay that out in your policy, and that, you know, notice and whatever makes sense to you. And you can't force an employee to take their vacation time to serve on a jury. So those are just some considerations. And then the last one for today is bereavement leave. This also comes up a lot where, you know, this is a sad time for employees. If they're having to look at this policy, it's not the best time. Ohio does not have a state law that requires bereavement leave, but employers can choose to offer this benefit to their employees. But if you do, you're going to want to address, you know, who is eligible. So is it someone who loses their mom, their dad, their child, you know, the sibling, or is it a very big, you know, is it their cousin, or is it whatever makes sense in law, and for how long? So sometimes immediate family member, so mother, father, child is a week, and then maybe an aunt or uncle is 1 or 2 days. So you, again, are not required to do this, but it definitely is an option to consider putting in your handbook.
Okay.
All right, we have a question. Great. Can an employee offer bereavement leave to hourly employees but not salary employees?
Okay, so maybe can an employer, you can, I mean, there are, you know, hourly and salary handbooks which have different policies.
Yes. And
I mean, that makes sense when you have someone who works by the hour saying, you know, we will provide you this time off, where someone who is on a salary, you know, they come and go as they please, so it's not a huge issue as long as they're working, you know, at night or whatever the case may be. But yeah, there's nothing that prohibits you from doing so, but I wouldn't do it like we talked about earlier. I forget what the example is, to certain employees and not, but as long as you're doing it to one category, so all salary employees it doesn't apply to, but hourly it does, that's okay.
It's very similar to the example of people working in the plant versus the office personnel. So as long as you have different departments and everybody within the departments are being treated similarly. So if you offer the benefits to everybody in the department, which would be the hourly employees, then you're fine.
All right, well, I think that was our last question. So thank you all for sticking around. We will have one more webinar in early fall to talk about code of conduct, I think, discrimination, harassment. So make sure you put something on all your, we're saving the best for the last. But yeah, thank you everyone for your time today.
Right, thank you very much.